Mr. Martinez Nolasco, I want to begin with you, but I'm waiting for the prosecutor to jump on the line.
Señor Martínez Nolasco, le habla el intérprete, pero le voy a interpretar todo lo que diga el juez. Acaba de decir el juez, señor Martínez Nolasco, se incorpore la llamada del fiscal.
Interpreter, you're breaking up.
Is that better?
Yeah, it sounds better.
Thank you.
We'll begin at 9 promptly, Mr. Martinez Nolasco. I do have the state's recommendation.
Bueno, señor Martínez Nolasco, vamos a esperar un minutito más a que se incorpore el fiscal, pero sí tengo la recomendación que sometió el fiscal.
Okay.
Okay.
All right. Morning, Neil.
Morning, Your Honor.
All right, Mr. Martinez Nolasco, this is the time set for your initial appearance.
Bueno, señor Martínez Nolasco, esta es la fecha y la hora para su comparecencia inicial.
We're going to go over your charges and conditions of release, but first I want to tell you a few things.
Bueno, vamos a repasar las acusaciones que tiene en su contra y también las condiciones de liberación.
You have the right to remain silent. Anything you say can be used against you.
Usted tiene el derecho de permanecer callado. Todo lo que diga puede y será utilizado en su contra.
You have the right to an attorney. I'll be appointing the public defender's office to represent you, and you have an attorney sitting to your left to help you in this hearing.
Bueno, le voy a asignar un defensor público para que lo represente, pero para el propósito de esta audiencia del día de hoy, usted tiene un abogado sentado a su izquierda para esta audiencia.
Okay.
If you are released or you post bond and you fail to appear at a future court hearing, a warrant could issue for your arrest.
Bueno, si usted sale libre o paga la fianza y no se presenta a sus próximas audiencias, se puede emitir una orden de arresto en su contra.
Before we go over the conditions of release, know that I've reviewed information provided to me from law enforcement, from pretrial services. I've reviewed the state's request for bond, and I'll hear from your attorney as well as the state.
Bueno, entonces, antes de decirle cuáles son las condiciones de liberación, yo ya estudié el caso, ya leí el informe que me presentaron los agentes del orden público, la recomendación de los servicios previos al juicio y también la recomendación para fijarle fianza. Y antes de escuchar más, voy a escuchar al abogado defensor y luego al fiscal.
My inclination, counsel, is to hold Mr. Martinez Nolasco on a $10,000 cash or secured bond with an order to not have any contact with the alleged victims or return to the incident location. So either party wish to be heard.
Your Honor, the state.
May I, Mr. Poston? Thank you.
Sorry.
Dice el juez que está considerando mantenerlo detenido al señor Martínez Nolasco y fijarle una fianza de $10,000, ya sea en efectivo o en garantía. Y también como parte de las condiciones de liberación, no puede tener contacto con la víctima ni tampoco regresar al lugar del incidente. Alguna de las partes quiere ser escuchado y dice el fiscal que sí. Go ahead, Mr. Poston. Thank you.
Your Honor, the state would urge the court to institute a $25,000 bond. The court is well aware of the absolutely mortifying statistics regarding strangulation in a DV situation. This person has demonstrated they have the capacity to cross a line that once crossed becomes easier and easier to cross the next time, and therefore the victim is at dire risk.
Thank you, Mr. Poston. Mr. Becker?
Okay, may I, Your Honor?
I'm sorry, thank you.
Thank you. Thank you. Dice el fiscal, su señoría, yo le ruego que le imponga una fianza de $25,000 a esta persona, porque como usted muy bien ya sabe, es absolutamente horrorífico un estrangulamiento o una situación de estrangulamiento que se considera violencia doméstica. Esta persona ya se pasó de la raya y sería muy fácil para él volver a hacerlo. Entonces, yo pienso que la comunidad está en riesgo grave.
Mr. Becker?
Thank you, Your Honor. I wish to point out a couple of different things. First off, Mr. Martinez Nolasco is very young. Additionally, his NCA was at a 2, and his failure to appear is at a 1. Part of the purpose of a bond is to ensure appearances in court, and he's just as likely as I am to show up for any future proceedings.
Okay. Y dice el abogado defensor Becker, su señoría, yo quisiera señalar algunas cuantas cosas para el señor Martínez Nolasco. Primeramente, el señor es muy joven y salió en la escala de NCA, salió en un 2 y la probabilidad de que sea un riesgo de que no comparecer es en el 1. Entonces, el propósito de fijar fianza es solamente para asegurarnos que la persona sí se presente a sus audiencias futuras.
I think everyone is aware of the statistics the state always uses when it comes to domestic violence regulations. However, I think the court should take into consideration past actions. Mr. Martinez Nolasco has no prior felony or misdemeanor or juvenile record for that matter. He does not live with the victim. Additionally, he has an address and he works in labor. There is a very low risk that him and the victim are going to run into each other, especially since the mother of the listed victim also additionally affirms that they don't live together and they're likely not going to see each other.
Okay, may I, counsel? Y
Yes.
dice el abogado defensor, yo pienso, su señoría, que como todo mundo conoce y sabe, la fiscalía utiliza estas estadísticas de estrangulamiento en casos de violencia doméstica. Pero yo considero que usted debe de considerar el historial del cliente, porque el señor Martínez Nolasco no tiene delitos graves, no tiene antecedentes penales, no tiene historial en el Tribunal de Menores y el señor no vive con la víctima. Creo que no va a tener contacto con la víctima porque él tiene otra dirección y él trabaja, tiene un trabajo manual y también él no es un riesgo porque él y la víctima pues no tienen contacto y no viven juntos y esto pudo verificarse por la mamá de la víctima y dijo que no viven.
And for that reason, Your Honor, we're asking for a much reduced $2,000 secured bond with release to pretrial services if posted. Thank you.
Y por esa razón, su señoría, estamos solicitando que se le reduzca a una fianza de $2,000 en garantía y si queda libre, que quede bajo la supervisión de los servicios previos al juicio si él deposita esa fianza.
All right, I hear both counsel's arguments. I'm going to make both of you unhappy. I'm going to affirm the $10,000 cash as secured bond I initially determined was appropriate in this case. Mr. Martinez Nolasco, if you are released, you may have no contact with the alleged victim.
Bueno, voy a hacer muy infelices a las dos partes porque voy a ordenar, dice el juez, la fianza en efectivo o en garantía de $10,000 como yo inicialmente lo había dicho y determino que es una fianza apropiada. Y también, señor Martínez Nolasco, usted no debe de tener contacto con la víctima si deposita la fianza y sale libre.
You have a preliminary hearing set for December 15th at 1:30 p.m. That court is not going to go. Contact your attorney regarding what to.
I'm sorry, Your Honor, you broke up. The interpreter just heard the next preliminary hearing is on the 15th of December at 1:30, and then I didn't hear anything.
Thank you. I said that hearing is unlikely to go, and I advised Mr. Martinez Nolasco to please talk to his attorney about the next steps.
Bueno, señor, usted tiene una audiencia fijada preliminar para el 15 de diciembre a la 1:30. Muy probablemente no se efectúe esa audiencia. Entonces, le recomiendo que se comunique con su abogado.
Your excuse.
Ok. ¿Puedo hacer una pregunta?
Can I ask something?
You may, but I suggest you ask your attorney first.
Bueno, sí puede, pero le sugiero que se la haga a su abogado primero.
¿Es usted?
Un abogado, sí.
You may ask, I forgot, thank you, Becker. Sir, you may ask a question. I'd advise you, because you have a right to remain silent, not to say anything about the facts of the case.
Bueno, señor, sí tiene derecho a preguntar, pero yo le recomiendo que guarde silencio porque usted tiene el derecho de permanecer callado y no decir nada de los hechos del caso.
Okay.
Ok,
You're excused, then, sir.
se puede retirar, gracias.
Yeah.
Sí.
And Your Honor, may the interpreter be excused?
JL, can we confirm there's no more Spanish speakers?
Yeah, he's back here, Your Honor.
All right, thank you. Yes, thank you, interpreter. Appreciate that.
Thank you very much. Have a good day.
You too.
Yep, and I can borrow. Holy cow. Oh, there's one right here. Thank you. Wait. Oh,
Judge, I see.
Yep, we're good.
Both suspended?
You're on a misdemeanor. I only do felonies.
Oh.
So the judge will talk to you.
Okay.
Sir, your name, please?
Kevin Morales?
Okay, Mr. Morales, give me 1 second here to pull up the file.
Yes, sir.
All right, Mr. Morales, I'm seeing you on CR 250126444. Looks like this is a suspended, a failure to appear, comply with something on a suspended license. No, hold on here.
It's probably for shoplifting.
Uplifting. All right. So I'm going to release you, sir, on your promise to appear at court. You're going to have court on December 15th,
Okay.
8:30 in the morning, okay, in Justice Court in front of Judge Foster.
Can I ask a question?
Yeah.
Can I get appointed to a public defender?
So it's a Justice Court case. There aren't public defenders for Justice Court. There are contract attorneys, but because I'm releasing you, I'm not going to appoint you an attorney.
Okay.
Hold on here. All right, sir, you can ask Judge Foster if you can be appointed an attorney, but I'm not going to do that today, given the
Okay.
fact that I'm not holding you, okay?
All right.
So go to court though on December 15th at 8:30 and talk to Judge Foster.
Yes, sir. I will.
All right, sir, you're excused.
Thank you.
Your name, sir?
Alan Ornelas.
All right, Mr. Ornelas. Before we begin, I want to go over some rights with you. First, you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. I'm going to be appointing the public defender's office to represent you, and you have an attorney sitting right next to you. If you don't hear at future hearings, whether you bond out or whether you're released, warrant could issue for your arrest. I'm seeing you on a felony warrant case out of Justice Court. This is on a third-degree burglary case. You also have a probation violation warrant on CR 20241717. and a probation hold.
Can I ask something by any chance?
Talk to Mr. Becker first.
We can proceed forward, Your Honor.
Mr. Ornelas, my inclination is to hold you on a $5,000 cash secured bond in order not to contact the alleged victim, not to return it to the location. If you post that bond, you will not be released from jail because you have a probation hold. Does other party wish to be heard?
No, Your Honor.
Mr. Becker?
Sure, Your Honor. Mr. Ornelas does have stable housing. He works as a roofer. His mom verified that and said that she'd be able to take third-party custody of him. I know APD has a hold, but because they already have a hold on him, I would ask for a reduced bond of $1,000 secured. So that way he's earning time on this, but his family can post that should the hold be released.
All right, Mr. Ornelas, I'm going to affirm the bond. I initially suggested of $5,000. Your attorney can file a motion to modify your conditions of release, ask for probation to lift their hold, and if the next judge thinks it's appropriate, they can release you on both these matters, sir. You've got a court date of December 15th at 1:30 p.m. At the preliminary hearing, it is unlikely to go. I'm going to appoint the public defender to represent you. Please talk to them about the next steps.
Okay, thank you.
Thank you, sir.
It's the phone number for the public.
Sir, your name?
Oh, this is the same person, Your Honor.
Oh.
I thought so. Thank you. Thanks. Becker, I think you're off the hook for a while.
All right. I'll take it now. I wish.
May the mayor stand up in order from this way. Go next.
Are you Mr. Bates, sir?
Yes.
All right, Mr. Bates, and for those gentlemen who just are also in the courtroom behind the divider, and if there's a lady there as well. I want to go over a few rights that you all have. You all have the right to remain silent. Anything you say can be used against you. You have the right to hire an attorney. You may have the right to have one appointed by the court. I might be doing that this morning, or you can request an appointed attorney at a future court date. If you fail to appear at hearings, a warrant could issue for your arrest. Before I go over your conditions of release and your charges, know that I've reviewed information in the court's file from law enforcement as well as pretrial services if they reported anything to me. All right, Mr. Bates, I'm seeing you on CR 250071. This looks like a failure to appear or comply with an earlier criminal trespass case. I'm going to release you on your promise to appear at a future court date. I'm going to set that court date for December 15th at 8:30 in the morning in front of Judge Pesquera. That's in Pima County Justice Court. Don't go to the incident location, wherever that was that you were trespassed from. Understood, sir?
Yes.
All right, sir, you're excused.
Your Honor, he also has another justice court case.
Oh, thank you, jail. Sorry, Mr. Bates. Give me 1 second here. All right, sir. You have a disorderly conduct failure to appear comply as well. That's CR 250127118. I'm going to release you on that one as well. 8:30 a.m. with Judge Cornejo. No contact with whoever the alleged victim is. Do not go to the incident location on this one as well, sir. Otherwise, go to court on December 15th at 8:30 in Justice Court. All right, sir?
Okay.
So you're excused. Your name, sir?
Alejandro Rene Jaramillo.
All right, Mr. Jaramillo. This is CR 188188954. This is a failure to appear comply with an earlier charge of domestic violence assault. I'm going to release you, sir, on your promise to go to court on December 16th at 9 a.m. in front of Judge Foster. Can you do that, sir?
Yes, sir.
All right. No contact with the alleged victims. Do not go to the incident location, wherever that is.
Yes,
All
sir.
right, sir?
Yes, sir. Thank you.
Your excuse, sir.
Your
Sorry.
Honor, he also has a city case.
Oh, sorry.
That's my bad. I didn't.
Sorry about that.
Oh, I see it now. I had the wrong file. All right. My bad. All right, sir, on the city court case, it's CM 17062566. This is a failure to appear comply with an earlier charges of harassment by communication from October 26th of 2017. I'm going to release you again, sir. No contact with the alleged victim in that case. You have court on January 13th of next year at 1:30 p.m. in front of Judge Million. If you know what the court's expecting you to do, I'd suggest you get some of that done before you go in front of Judge Million on January 13th, sir, all right?
Am I gonna get paid? I don't know nothing about this case. It's been so long, I don't know nothing. Am I gonna get the papers? I could apply?
Hold on.
Okay, thank you.
So, sir, I don't have much in the file here. Let me know what the court ordered you to do.
Okay,
Go to court on January 13th. Robert, do you see? Oh. So, sir, it sounds like you've never appeared for this old case. January 13th, 26, 1:30 PM in front of Judge Millian at Tucson City Court. You're gonna get paperwork regarding both these cases, all right, sir? Go to court.
thank you so much. Have a great day.
You're good. Thank you both. Sir, your name?
Jason Cooley.
Mr. Cruz, you want CR 25016. This is one count of disorderly conduct fighting, domestic violence offense. Sir, I'm going to release you on your promise to appear at court. You have court on December 15th at 10:30 a.m. in front of Judge Cornejo at Pima County Justice Court. I can't promise, you, but go to Pima County Justice Court on December 15th at 10:30 a.m. All right, sir?
Okay, sounds good. Thank you.
You're excused.
Yeah, you'll get some paperwork. Okay.
I still don't have an hour.
Oh, you'll probably get it later.
Back to the former attorney.
Name, sir?
Mark Detective.
I'm Sanchez. I'm seeing you on CR 230171155. This is a failure to appear comply with an earlier shoplifting charge. I'm going to release you on your promise to appear at court. You've got a case management conference on January 8th in Pima County Justice Court. You'll get paperwork on this court date. It's at 10:30 a.m. All right, sir?
Okay.
Don't go to incident location wherever it is they're alleging you shoplift. And go back there. All right, sir?
Apparently he's got a probation hold, Your Honor.
Thank you, counsel. Hold on. All right, sir. Well, in that case, let me hold you on a $5 bond. That way you're getting time credit on this case. All right, sir? I'm going to appoint Jill Gookin to represent you since I'm holding you on a bond. Your next court date instead will be December 4th. That's tomorrow. It'll be a video review hearing at 1 p.m. in front of Judge Foreman. All right, sir?
Okay, thank you.
You can deal with this case rapidly. All right, sir, you're excused then.
Thank you.
Your name, please, sir?
Peter Arias, gentleman, wood. Goodbye.
All right, sir. I'm seeing you on CM 250444393. This is a city court case, one count of shoplifting. Sir, I'm going to release you on your promise to appear. I understand you're being held there on a probation hold, though. Because of that, I'm going to set a non-transport review hearing on January 16th at 9 a.m. and appoint the city PD to represent you. Hopefully they can take care of this case without you present. Maybe get it dismissed because of your pending felony case. All right, sir?
All right.
You are released. You can't go to 9615 East Old Spanish Trail. Understand that?
Sure.
This is also time for your arraignment. I've set a future court date. You have a non-transport review hearing. However, if you do have a future court date you're required to appear at and you don't appear, a warrant could issue for your arrest and trial could go forward in your absence. If you're convicted at trial and don't appear for sentencing within 90 days, you can lose your right to appeal. Understand that, sir?
Yes, sir.
So you're excused. You're excused, sir.
Please wait. Please wait. On the third, back to the far left corner. Next. Guys, next. Send that right check.
Who are you? Your farm side? Sir, your name? Mr. Bustamante, I'm seeing you on a number of cases for city court. It's CM 250359495, 250359497, and 0010218. Counts of criminal trespass, possession of prescription drugs without a prescription, possession of paraphernalia. Multiple counts of those. So I'm going to hold you on a $1,100 cash or secured bond. If you do post bond, I'm going to order you not to go to 437 West Thurber Road. I'm going to appoint the city PD to represent you. You'll have a video review hearing on December 9th at 1:45 p.m. This is also your arraignment, sir. I've set that hearing for you. If you do bond out and you don't go to future hearings, a warrant could issue for your arrest. If you are convicted at trial and don't appear for sentencing within 90 days, you can lose your right to appeal. Understand, sir? Sir? You understand all that?
Yeah.
Mr. Bustamante, you're
Yes, I do.
okay. You're excused, sir. Your name, sir?
Matthew Clark.
Mr. Clark, I'm seeing you on CM 25002966 and 250191158. These are failure to appear or complies with criminal trespass, criminal damage.
Yes, sir.
I'm going to set a bond of $500 cash or secured, order you not to go to 2505 East Executive Drive, appoint the city PD to represent you. You've got a video review hearing on December 9th at 1:45 p.m. in front of Judge Mayhew. If you post bond and you don't appear for a future hearing, a warrant could issue for your arrest. If you are convicted at trial and don't appear for sentencing within 90 days, you can lose your right to appeal. Understand that, sir?
Yes, sir.
So you're excused. Your name, please, ma'am?
Lynette Palmer.
Ms. Palmer, I'm seeing you on multiple counts from city court. It's CM 190744621, 250443999, 250443669. These are charges of using electronic communication to threaten or intimidate disorderly conduct, assault, criminal damage, and again, disorderly conduct. And there's a victim on the phone as well, who I believe wished to be heard. Sir or ma'am, would you please state your name?
Alicia Donia Palmer.
All right, Alicia Palmer, what did you want to say, ma'am?
I would just like to say that me and my children are very traumatized about what had happened, and we just give it to the court for justice.
Okay, thank you, Ms. Palmer. Right now, though, this is the time for Ms. Palmer's initial appearance. So you have a right to be heard at future court dates regarding what occurs with this case. Right now, I'm just determining whether or not Ms. Palmer should be released. Ms. Palmer, I'm going to hold you on a $2,500 cash bond, appoint the city PD to represent you. You've got court on December 9th at 1:30 p.m. It's a video review hearing in front of Judge Verena. If you do post bond and you fail to appear at future court hearings, a warrant could issue for your arrest. Trial could go forward in your absence. If you don't appear for sentencing within 90 days of a conviction, you'll lose your right to appeal. Understand that, ma'am?
So I'm not being released today?
You are, well, if you post bond, you can, ma'am, but I'm holding you on a bond of $2,500 cash.
Okay, thank you.
Ma'am, you're excused.
Torres,
You. Your name, please, sir?
Torres,
Mr. Torres, this is CM 25015-162, one count of disorderly conduct. This is a time for your arraignment on your petition to revoke probation. The Assistant City Prosecutor alleges that on August 8th of 25, you were judged guilty of disorderly conduct. You were placed on probation for 24 months. Written conditions of probation were given to you. The court has petitioned your revoke because there's reasonable cause to believe that conditions of probation have been violated. The specific issues of non-compliance are failure to complete domestic violence intake session, failure to report for monthly monitoring appointment on September and October, and failure to pay monthly monitoring fees. You understand that, sir?
Sure.
All right. I'm going to deny the allegation. I'm going to appoint the city public defender to represent you. I'm going to set a hearing of December 30th at 2:30 p.m. in front of Judge Mayhew in Tucson City Court. You understand that, sir?
Sure.
All right. So you've got court December 30th. Call your attorney. I would suggest that before you go to see Judge Mayhew on December 30th, you do at least some of the things that the court ordered you to do back in October of 25. Okay, sir?
yes, sir.
All right, sir, you're excused.
Your Honor, you released?
You've been released. Yep.
Consola,
Your name, sir?
James Valenzuela.
Mr. Valenzuela. I'm seeing you on CM 25044-394. This is one count of criminal trespass, one count of obstruction. So my inclination, man, is to hold you on a $100 cash bond. Do you want to be heard on that? Not you, Becker, but you, Mr. Valenzuela?
No, I don't have no money for anything, so
If I release you, you're going to come to court?
yes, sir.
Will you stay away from 205 West Valencia Road?
Okay,
The place you were at, I guess, last night, right?
yeah, I believe so.
You'll stay away from there?
Yes, sir.
All right. All right, I'm gonna release you. Jackie, did you have one of these? I don't need one this second, but. Oh, thank you very much, Robert. I got one. Thanks. All right. Yeah, $5. Yeah, because of the probation hold. All right, sir, I'm gonna release you, like I said, in your promise to appear at court. You've got court on January 5th, Tucson City Court in front of Judge Hale, okay?
Okay,
All right, man. You're excused.
thank you, Your Honor.
You're welcome, sir. You good? I always forget the second pages. Thanks. Your name, sir?
Billy Riojas.
I'm sorry, sir. Say that again.
Huh?
Say your name again, sir?
Billy Riojas.
Why did we skip so much? Thank you, Robert. Why did we skip so much, you know? Hey, Becker, Mr. Riojas is here on a felony jail. Do we have other individuals that are here on felonies in the courtroom?
No, Your Honor, we can keep separate.
Thank you. That is not reflected in the paperwork we have.
The list was amended, Your Honor.
Sorry, sir?
The list was amended for 105.
Okay. All right, Mr. Riojas, I'm seeing you on CR 250164522.
Yes, sir.
Were you in the courtroom when I went over the risks of not appearing at a future hearing and your constitutional rights?
No, sir.
But sir, you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. Because this is a felony case, I'll be appointing the public defender to represent you. You also have an attorney sitting right next to you today. If you fail to appear at a future hearing, whether I release you or whether you postpone, a warrant could issue for your arrest. Before we go over your conditions of release, know that I've reviewed the charges from law enforcement. I've reviewed pretrial services report, and I'll listen to both attorneys on recommendations. Sir, it looks like you have a DOC hold. My inclination is to hold you on a $2,500 cash or secured bond. Understanding that if you post that bond, you still will not be released from jail and you won't be getting time credit on the new count. Understand that, sir?
Yes, sir.
Other party wish to be heard?
No, Your Honor.
Becker?
Sure, Your Honor, I just wish to emphasize that, these intent to facilitate shoplifting cases, the fact that he used a bag to shoplift items, which might be a misdemeanor, suddenly elevates it here to a felony. I just hope that the court would take that into consideration and that he does have a residence. I understand he has the hold, but for those reasons, we would ask for at least a more nominal bond in this case. Thank you.
I hear you, counsel. Mr. Rose, I'm going to hold you on that bond. If your attorney can convince the judge to release you on your probation case back to probation, they'll also convince the court to lower the bond, okay?
Sure.
We've got court on December 15th
You're,
at 1:30 p.m. That court is unlikely to go. Talk to your attorney about what that means. I'm going to appoint the PD to represent you, all right, sir?
Your Honor, what was the bond amount?
2,500 cash or secured. And Mr. Riojas, you're excused.
Sure.
Mr. Riojas, your counsel has some paperwork for you there.
Thank you for that, Your Honor.
Good luck, Mr. Riojas.
Thank you.
Your Honor, the order seems a bit out of sequence. Who do we have next?
It should be timed. I'm not sure why Riojas was a keep separate all of a sudden. Unless he always was and just the paperwork I got this morning didn't reflect that. I understand why Mr. Tynes is a keep separate.
Just trying to stay.
For administrative
segregation,
segregation,
Your
Oh, thank you, Gail. Thank you.
And Your Honor, before I forget, we get the times, I ask that we waive reading.
Yes. State your name, please.
Inez Tynes, TYNES, sir.
Mr. Tynes,
Yes, sir.
here on CR 250164447. Your attorney's waived reading of the charges. Before we begin, you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. I'm going to appoint the Pima County Public Defender's Office to represent you. You have an attorney sitting next to you right now as well.
Sir.
If you post bond or if you're released and you don't appear to future court date, a warrant could issue for your arrest.
Sir.
Before we go over your conditions of release, know that I've reviewed the charges proposed by, or the alleged charges by pretrial service, the alleged charges by law enforcement. I've reviewed the report by pretrial services, and I'll listen both the prosecutor and the defense attorney with their arguments as to bond. All right.
Yes, sir.
State, you want to go ahead first? I see that you're requesting
Yes.
$6,000.
Yes, Your Honor. The state's requesting $250,000. This person is only charged with a certain number of counts based on the information, but as the court can see in the interim complaint, there are a order of magnitude more of these incidents that could result in additional charges. The sheer time that this individual could be sentenced to in prison cannot be overestimated. That alone makes this individual a flight risk. Plus, this individual's actions fuel a most insidious industry that does nothing but cause pain, suffering, and exploitation. Nothing short of custody will ensure this person does not have the ability to reoffend, nothing short of a Faraday cage, because even the modern television, the modern smartphone, it's all connected to the internet. And there is absolutely zero way to prevent him from reoffending if he is released. Your Honor, the interests of justice demand a high bond. Thank you.
Thank you, counsel. Mr. Becker?
Sure. Your Honor, I do wish to emphasize that Mr. Tynes has no prior felony history. Additionally, he has a stable residence here in Tucson. I understand the gravity of the situation that Mr. Tynes is looking at right now. However, the $250,000 bond requested by the state is a substantial bond that I don't think anybody realistically could post without intervention. Mr. Tynes does not have the means to be able to even get remotely close to that. And so here it acts essentially as a no bond. So because of that, Your Honor, we're asking that there at least be a possibility that Mr. Tynes be allowed to post bond. Not saying that he'll be able to, but at least create the possibility of it and reduce it substantially. Thank you, Your Honor.
Thank you, counsel. I'm going to hold you on a $100,000 cash for secured bond. If you do post that bond, you may have no contact with minors. I'm going to appoint the PD to represent you. You'll have a court date of December 15th at 1:30 p.m. That court date is unlikely to go. Please speak to your counsel about next steps. All right, sir?
Your Honor?
Yes, sir.
Your Honor,
Yes, sir.
the state would request that court enter an order forbidding him from going near schools, daycare facilities, parks, also that he have no access to any electronic device with access to the internet other than the jail tablets whilst he is in custody.
I'll do that. Listen.
No, I don't think that there's still any. Your Honor, is he excused?
Hold on, jail, sorry. Sir, if you do post bond, you may have no access to the internet. While you're in jail, you can't have access to the tablet. If you do post bond, you may not go within 100 yards of any place where children are located, aside from grocery stores for your own needs. All right, so you're excused.
Your Honor, this is the jail.
Yep.
Mr. Godoy has his own attorney and the attorney is present. Is it possible to do him first to get this out of the way?
Absolutely.
And Your Honor, I'll step out of the way here.
Thanks, Mr. Becker.
All right, felony. Wait.
Yeah, of course.
Upstairs.
Oh, sorry.
All you have to do is speak, they can hear you and all stuff, okay?
Awesome, thank you. Hello, Your Honor.
Give me 1 second, Mr. Godoy.
And Your Honor, the rest of the felonies are present behind the partition.
Appreciate that, jail. All right, Mr. Godoy and ladies and gentlemen who are behind the partition, this is the time set for your initial appearance. We're going to go over your conditions of release as well as your charges, but first, you all have the right to remain silent. You have the right to an attorney. I'm going to be appointing an attorney to represent each and every one of you. Mr. Godoy, your attorney is sitting next to you. For the rest of you, Mr. Becker is also in the courtroom. He'll be sitting next to you at your turn. If you are released or if you post bond and you fail to appear at a future hearing, a warrant could issue for your arrest. Okay, Mr. Godoy, I'm seeing you on CR 25016-448. This is one count of domestic violence aggravated assault for the violation of a protection order. My inclination, counsel, is to hold Mr. Godoy on a $2,500 cash bond with orders not to have any contact with the alleged victims, and if he is post that bond, not to go to the incident location. Does counsel wish to be heard?
Yes, Your Honor, thank you. This is Veronica Lamont Darnell, and I'm with the Your Honor's permission, I would be just with an oral notice, a limited notice of appearance for this hearing, and I'll file a written one later on this afternoon, if that's fine.
Of course.
Okay, thank you. So on this, Your Honor, I would like to make a motion to dismiss. And if necessary, after that, if it's not granted, I would like to discuss the release conditions as being more than what is needed for Mr. Godoy. So may I be heard on the motion?
You may.
Okay, thank you. So Your Honor, the paperwork that I have received is that there was a search warrant that was presented to Mr. Godoy, not an arrest warrant. And from what I understand, that is not allowed under Arizona revised statutes. I'm sorry, I don't have the case number with me, but I could file a memo on that with the case, with the statute number, but that's not sufficient notice making this whole arrest defective. And so that's why the defense is requesting that this matter be dismissed with prejudice.
So counsel, what I see is that there's an allegation that on November 5th, Mr. Godoy assaulted his ex-girlfriend, allegedly assaulted his ex-girlfriend with a valid protection order in place. I don't see anything about a search warrant being served on him.
Okay, so I guess that would lead me to some questions about whether there was due process so far in that I believe that there was paperwork that was sent to his attorneys, that his other attorneys that he had at that time by the prosecutors, and they were still getting in contact with Mr. Godoy, even though he has an attorney, and then they just he's just popped up and they arrest him on this, with giving him a document that says it's a search warrant. That's basically what I'm saying, is that there is that, is defective.
Judge,
Yeah, Neil.
I didn't hear a cognizable argument there. We're just looking at somebody that there was an order of protection and they happened upon the victim whilst on the road, and apparently Starbucks became a projectile, and here we are. So anything about warrants, search warrant, I don't even see search warrants here. The only paperwork I'm aware of right now is the order of protection that was in effect. It expires December of next year. And as the court knows, in roundabout terms, when somebody is given an OP, when somebody is notified that they have an OP, the gist of it is, if you see this person on the road, you will turn around and you will go away. If you are in a restaurant and they walk in, you walk out. These due process arguments not only aren't ripe or timely, but I'm not even able to make heads or tails of what's going on with this argument. So, Judge, the state would oppose these motions. The state has no problem with the verbal notice of appearance on the part of the counsel for the defense, but state stands by its recommendation of $5,000.
Right. So.
Wait, I thought it was a 2,500.
So the state's recommendation is 5,000. Mr. Godoy, I hear what counsel is saying. If she has a due process argument to make at a later date, she can make that. The information that's been provided to the court is that you were served with a valid order of protection, and then there's an allegation that you violated the order of protection with a assault on your ex-girlfriend. I'm going to hold you on a $2,500 cash bond. I will appoint the public defender. Your attorney can file a notice of appearance, in which case the PD will be relieved. You've got a court date on December 15th at 1:30 p.m. in Justice Court. That court date's not going to go. Talk to your attorney about what that looks like in the future. Regardless of your bond conditions, you may have no contact with the alleged victim, as already ordered. Your excuse, sir.
Oh, Your Honor, just really quickly, do I have leave to file more on the arguments that I was making in my motion to dismiss?
You do, but this court won't have jurisdiction to determine the validity of those arguments anymore.
Okay.
File that with Superior Court.
Okay.
Counsel,
All right. Thank you so much.
Counsel, may I have your name for my records, please?
Veronica Lamotte, LAMOTTE DARNELL.
Thank you, Mr. Lamotte. Thank you.
Thank you.
So your name?
Ivan Acevedo.
Mr. Acevedo, I'm seeing you on CR 25016-458. This is one count of possession of narcotic drugs, one count of criminal trespass. Sir, you are eligible for STEPS Court. Have you heard of that program?
No.
So I don't know if you have a drug problem. I don't want to judge any drug problems. If you do have a drug problem and you want treatment for that drug problem, the STEPS program might help you on that way. It's a program that allows the state to dismiss these charges if you comply with certain conditions of drug treatment. Are you interested in that?
Yes.
All right. I'm going to set a steps hearing for you on December 10th. I'm going to release you to pretrial services. So 2 things. 1, you got to go to that hearing on December 10th if you want any chance of getting into the steps court. Okay, you have to go. 2, call pretrial services. All right, you'll get their contact information when you are released from the jail. 3, if you need help with housing in the meantime, there's a transition center outside of the jail. They can help you with some kind of resources, so that you at least have some plans for tonight and tomorrow night. All right.
Yes, sir.
You've got court on December 10th. I'm setting another court date of January 20th. Counsel, do you waive time for that?
Yes, Your Honor.
So all I'm asking, Mr. Acevedo, is that if your attorney will waive time for the state to determine whether or not they should indict you, because I've set that steps court hearing, so hopefully they'll dismiss this case if you do what you're directed to do by the court judge, by the judge, okay?
All right.
All right, man. So go to court on December 10th. I'm going to appoint the PD to represent you in this case. And with that, sir, you're excused.
Thank you.
It's not really.
Wait.
So back to the public forum.
Sir, your name, please.
Christopher Adderley.
All right, Mr. Adderley, I'm seeing you on a couple matters here. I'm seeing you on CR 2025-5159. This is theft by control and forgery. I'm also seeing you on a possession of a dangerous drug. I'm seeing you on a city court case as well for failure to appear. Let me start with the felony cases, sir. Sir, did you hear me tell the last gentleman about steps court?
Yes, I did.
Are you interested in that?
Yes, Your Honor.
All right, sir. I'm going to set a steps court hearing on December 10th at 9 a.m. I'm going to set a preliminary hearing on January 20th. The January 20th date is a placeholder date for the state to determine whether they should charge you with this offense. Talk to your attorney about what that means. The most important thing for you right now is to go to court on December 10th, all right? Please call pretrial services as well. I'm going to release you on your promise to, well, I'm going to release you to pretrial services, which means I'm not going to hold you on a bond, but you do need to check on with pretrial services, okay?
Yes.
I'm going to point the
Yes, Your
public,
Honor. Thank you.
I'm going to appoint the public defender's office to represent you in this case. All right, on your city court case, sir, it's CM. Oh, hold on.
Let's-
Hold on.
Yeah.
All right, on CR 2025-5159. That's also a Superior Court case. I'm going to release you to pretrial services as well, sir. I'm going to set your arraignment on December 11th at 1:30. That's with me, okay? So you got 2 court dates you got to go to if you want help, all right? The first date is important. The December 10th court date, that's the court date that's going to determine whether or not you can get into the steps court program. The second court date, December 11th, that's the next day. I know this sucks, man. Go to that court. That's the arraignment. All right. If you show up, I'm going to continue to release you. not issue a warrant for your arrest and wish you best of luck on these charges, okay? I'm gonna appoint the PD's office to represent you. I don't know what the charges are. Looks like some theft charge. No contact with the alleged victim. Don't go to the incident location, okay?
Okay.
You're released to pretrial services. They'll tell me if you've been calling them. You gotta do that. Understand?
Yes, Your Honor.
If you got questions, talk to Mr. Becker after court.
Okay.
All right, as to the city court case. I'm gonna release you. I promise to appear again. Lots of court dates, man, I know. You're gonna get paperwork, just save it, okay?
Okay.
You've got a court date on January 6th at 1 p.m. in front of Judge Seaman, that's Veterans Court. So thank you for your service, sir.
Thank you, Your Honor.
All right, 3 court dates. They're all important. December 10th, December 11th, and January 6th, all right?
Yes.
All right, sir, you're excused.
That's it, call on last day.
Counsel, I'm sorry, I didn't give you a chance to speak on behalf of that last case. I apologize.
Not a problem.
If either counsel, if I do that again, please jump in and let me know you want to be heard.
Yes, sir.
Sir,
Will
your
do.
name? Thank you. Sir, your name?
Zachary Edward Connolly.
Mr. Connolly. I'm seeing you on CR 250164557. 1 count of possession of a narcotic drug, 1 count of intent to facilitate shoplifting, 1 count of paraphernalia. Counsel, my inclination is to hold Mr. Connolly on a $3,300 cash and secured bond as suggested by the issuing, hold on.
I'm sorry, Judge, where are you seeing 3,300?
I'm sorry, give me 1 second. I'm trying to find where this was coming from. All right, well, I had written down 3,300. That was my initial inclination. I'm not sure where I got that number from. So I certainly want to hear from counsel as to their recommendations. Neil, you want to start?
State submits on the written record.
Okay, Mr. Becker?
Sure, Your Honor. Once again, this is kind of a low-level shoplift. I think the total was $19.67 plus some additional other items that were non-priced. Additionally, he was found with 2 pills on him. It's clear that this is a result of a substance abuse issue and not anything malicious. Additionally, even a $3,300 bond is going to be pretty substantial. His sister is willing to transport him to future court hearings. And so with all of those combined, we're asking for a reduced bond of $1,000 secured or release to pretrial services.
So Mr. Connolly, I see where I got that amount from, and here's why I'm going to hold you on that $3,300 bond. It looks like on a 2021 case, you had a number of releases to pretrial services and a number of FTAs at arraignment. I think I counted 7. And then ultimately you were held on a $1,000 bond, you were released and you had a warrant issued again. Finally, you were held on a $3,300 bond and then your case was resolved. I'm going to hold you on that same bond, sir, $3,300 cash or secured. I'm going to appoint the public defender's office to represent you. I'm going to set a court hearing of December 15th at 1:30 p.m. That court hearing is unlikely to go. Speak to your attorney about your next steps, sir. Your excuse, sir. Your name, ma'am?
Chantel Hedges.
Okay, Ms. Hedges, I'm seeing you on CR 250164553. This is one count of possession of a dangerous drug for sale, one count of possession of a narcotic drug for sale. No, sorry, one count of possession of a narcotic drug not for sale, one count of possession of paraphernalia. State's asking for a $5,000 bond plus pretrial services and notice of a steps court hearing.
Judge, did you say it was this is or is not? Your Honor, if it's a sales case, this was confusing to me as well. Based on what I see now, the sales case is not eligible for steps.
I didn't think so, Mr. Poston.
My apologies, Your Honor.
Okay, sir. So Ms. Hedges, the state's asking for a $5,000 bond and pretrial service release. Mr. Becker, do you want to be heard?
Sure, Your Honor. She's employed as a supervisor here in Tucson. She has a stable residence. Her last criminal case was in 2020, of which, from my understanding, she completed probation successfully. I understand that there was a large amount of bills, but I do want to emphasize that this was split between two people, and it's pretty common to buy things in bulk and not necessarily keep them for sale. So I'd ask that the court take that into consideration and make the bond $1,000 secured plus pretrial services.
Your Honor, quantity is indicia of sales. That's just how things are. And spreading it around spreading a quantity around an area doesn't make it any less quantity.
Thank you, counsel. Give me 1 second. All right, Ms. Hedges, I'm going to hold you on a $1,100 cash bond. I'm going to appoint the legal defendant's office to represent you. If you post bond, you'll be monitored by pretrial services. You have a court date of December 15th at 1:30 p.m. That court date's unlikely to go. Talk to your attorney about what that means. And as of that, ma'am, you're excused.
I apologize, Your Honor. Is it just a cash bond or is it cash or secured?
It's just cash.
Okay, thank you.
Ma'am, your name, please.
Amber Maestas.
All right, Ms. Maestas. I'm seeing you here on CR 20253702, one count of theft by control, one count of fraud scheme occurring in June of 2023. Council, my inclination is to release Ms. Maestas to pretrial services. From what I understand from the assessment, it looks like she did not have notice of this court date. I understand the state's request for me to honor the $1,000 bond listed on the warrant. Neil or Mr. Becker, do you want to be heard further?
Court's prerogative, Your Honor.
Nothing from us, Your Honor.
All right, so Ms. Maestas, I'm going to release you to pretrial services. What that really means is you're going to need to call them and do what they say, which is generally calling. Ma'am, do you currently live in Texas?
I do.
So,
I have family here in town as well.
so say that again, ma'am?
I have family here in town as well.
Okay, I'll grant you permission to return to Texas until your case management conference, if that's where your life is. I'm also going to schedule an arraignment for you on December 11th at 1:30 p.m. If you have returned to Texas, you can appear remotely for your arraignment. All right. You must contact your attorney prior to the arraignment to facilitate how you can appear telephonically, but only if you're living in Texas. That being said, I can't promise you that the next judge is going to allow you to permanently live in Texas while this case is going on. So you'll need to discuss that with your attorney, okay? I can only grant you permission to live in Texas until your case management conference, which will be set by me on December 11th. You understand that, ma'am?
Yes.
Okay. I'm going to appoint the public defender's office to represent you. I am going to set that arraignment for December 11th at 1:30 p.m. in front of myself. Reach out to your attorney for information on what you're going to do next, okay, ma'am? Regardless of whether, well, I guess I'm releasing you. So, no contact with any of the alleged victims, whoever they are, I don't know, because this is a warrant case. Understood?
Yes.
All right, ma'am, you're excused.
Really quickly.
They shouldn't be that big. Robert. It seems silly. Yeah, well, we all stretch, like. Your name, please.
John Miller.
All right, Mr. Miller, I'm seeing you on CR 2501645. This is one count of trafficking, stolen property, one count of theft. State's asking for a $1,100 bond plus pretrial services. Council, my inclination is to release Mr. Miller to pretrial services over the state's objection with order to not to have any contact with the alleged victim and monitoring by pretrial services. Does other party wish to be heard?
Over state's objection.
Thank you, Neil. Mr. Becker?
Nothing from us, Your Honor.
So, Mr. Miller, I'm releasing you to pretrial services. I'm going to set a court date for you of December 23rd at 1:30 p.m. That court date is unlikely to go. Talk to your attorney about what that means.
Okay.
No contact with any of the alleged victims. I'm appointing the defender's office if I didn't already say so, sir.
Okay.
Your excuse, sir.
Let me mute.
So I understand you all placing bond for the case is in jail or to. So because you paid it to the jail, you should get all that money back. If you paid it to a bond company, they're gonna keep 10%, I can almost guarantee regardless of what happens next. But for the jail itself, they should give you the money back, all of it. Your name, sir?
Heath Moody.
Mr. Moody, I'm seeing you on CR 25016-456. There's one kind of unlawful possession of a dangerous drug, unlawful possession of paraphernalia. Give me 1 second, sir. I see you also have a probation hold. My inclination, counsel, is to hold you on that $2,500 cash or secured bond the state's requesting. Likely over your attorney's objection, Mr. Moody, given that you have a hold by adult probation. Does counsel wish to be heard?
No, Your Honor.
Mr. Becker?
Yes, Your Honor. We would ask for a reduced bond in this case. I mean, Mr. Moody has a Tucson address here. He is self-employed. And the facts of this case indicate that he had a very small amount of methamphetamine on him. It was not an egregious amount or anything like that. So we would ask for a much smaller bond amount of $1,000 secured.
Mr. Moody, I'm going to hold you on that $2,500 cash and secured bond over the defense objection. I see you got 4 probation violation warrants. No matter what I hold you on, you're not leaving the jail without the court's permission, and that would not be my permission. That would be with the Superior Court's permission. I'm going to set a steps hearing. I don't know whether you're going to be eligible or not, but I'm going to set a step screening hearing for December 10th at 9 a.m. So if the jail wakes you up to bring you to court on December 10th, it'd likely be in your interest to do that. You also have court December 15th at 1:30 p.m. That court date's unlikely to go. Talk to your counsel about kind of the next steps in the whole process. All right, so I'm going to appoint the PD's office to represent you. And with that, sir, you're excused.
Got a city case as well, Your Honor.
Sorry, Mr. Becker.
He has a city case as well, Your Honor.
Yeah, I'd like to set that for trial.
All right.
I was looking forward on it yesterday.
Thank you, Mr. Becker. I didn't see that.
I was just in court on that yesterday, Your Honor.
All right, thank you, sir. So actually, sir, I know this might seem odd. I'm going to release you on that case, and here's why. I'm going to set a non-transport review hearing for January 16 at 9 a.m. And I'm going to appoint the city PD to represent you on that case. Here's what happens at those. At those hearings, the city PD will discuss with the city prosecutor as to whether or not they should dismiss these charges given your pending felony matters. All right, sir?
Yes, sir.
All right, sir. You are now excused.
Is it bond attorney code number?
Yeah, that's what I thought.
Your name, ma'am?
Brenda Olivas.
Ms. Olivas, I'm seeing you on a couple different matters. I'm seeing you on CR 25016-462. This is one count of possession of a narcotic drug, one count of paraphernalia, one count of criminal trespass. I'm also seeing you on a number of city court matters. Looks like they're all failure to appears for either paraphernalia or trespassing. Ma'am, your steps eligible. Just from looking at all your charges, I'm not judging. It looks like you might have a drug problem. Have you heard about the steps program?
Yeah.
You understand that it would allow the state to dismiss these charges if you complied with the drug treatment program the court ordered you to do? Is that of interest to you?
Yes.
I'm going to set a steps hearing on December 10th at 9 a.m. You have to go to that, okay?
I will.
It's a screening. If you don't go to the screening, you can't get into the program, all right?
I will go.
I'm going to set a court date of January 20th at 1:30 p.m. That court date's not going to go. I just have to set it. Talk to your attorney about that. I'm going to appoint the legal defender's office to represent you. Counsel, my inclination on the felony is to release her to pretrial services. Does either party wish to be heard?
No, Your Honor.
Okay.
Nothing from us, Your Honor.
All right. Well, Ms. Olivas, I'm going to release you to pretrial services. So there's two really important things, okay? If you remember anything from this morning, you got to go to court December 10th. You just have to. All right. Second thing is you're going to get information from pretrial services about how to call them. Call them. All right.
Yes.
All right.
Thank you.
On your city court case. I'm going to release you again. You have a lot of FTAs. You're going to have court on January 9th at 1:30 in front of Judge Blue. He's a nice man, okay? Please go to these court dates.
Thank you.
Especially the December 10th court date. All right, ma'am, you're excused. Ma'am, your name?
Adriana Ortiz.
All right, Ms. Ortiz, I'm seeing you on CR 25016-451. This is one count of aggravated robbery, one count of aggravated assault, temporary disfigurement, one count of robbery. State's asking for a $15,000 bond plus pretrial services. Mr. Decker, do you want to be heard?
Yes, Your Honor. I mean, the fact of the matter is that her NCA and her FTA are both at 1. I know it's an old cliche line, but she has as much likelihood as anybody else of showing up. She has no prior felony or misdemeanor convictions, according to my records. She is actively working as a business admin manager. She has a stable residence here in Tucson. Her friend is able to take third-party custody of her. I understand that this is a pretty substantial and heavy case. However, she was, it seems to be initiated by the 2 men that she was with. And additionally, once again, kind of leaning into the fact that she has no priors, we would ask that she just be outright released to pretrial services, or in the alternative, a much more nominal bond, a secured bond, so that she can post it and continue with this court case accordingly.
Your Honor,
Go ahead, Mr. Plimpton.
this reads like an absolutely brutal assault, and whether or not somebody else initiated it is really besides the point because she decided to join in, allegedly. And this seems like it was an absolutely defenseless person. There is evidence of consciousness of guilt when she fled. This is problematic, Your Honor. This warrants a bond, and her lack of a history in her NCA FTAs are not congruent with the alleged events, and therefore the statistics here aren't terribly useful. The state asked for 15,000.
Your Honor, I wholeheartedly disagree with that. The point of the FTA and the NCA is to make some kind of assumptions as to whether or not the person is going to be committing new criminal conduct, and they take into account what the person is being accused of. And once again, she scored 1 and 1 here.
Thank you, counsel. Ms. Ortiz, notwithstanding your very low scores on your pre-sentence report, I'm going to hold you on a $10,000 cash as secured bond. You can have no contact with the alleged victim. You may not return to the incident location. I'm going to appoint the public defender to represent you. You have court on December 15th at 1:30. That court date's unlikely to go. Talk to your attorney about what that means. Your excuse, ma'am. Name your name, please.
Vanessa Quiroz.
All right, Ms. Quiroz, I'm seeing you on 3 different matters. I'm seeing you on 1 count of burglary in 2nd degree, 1 count of theft by control. I'm also seeing you on CR 20255036. That's an older case of burglary 3rd degree, theft by control, criminal damage, and I'm seeing you on an Oro Valley case as well. As to CR 250164446, that being the new case, my inclination, counsel, is to hold Ms. Quiroz on a $10,000 cash bond. Counsel, I assume, Mr. Becker, you wish to be heard?
Yes, Your Honor. I do want to emphasize that Mrs. Quiroz was in rehabilitative services when she was summoned on her older cases, has residence here. She's completed 1 probation successfully before. She has had prior work as a QC manager, working in the community. We would ask for, I think a $10,000 bond is much too substantial for Mrs. Quiroz to even be able to remotely afford. So we would ask for a nominal bond of $1,000 secured with release of pretrial services. Thank you.
Mr. Poston, I'm inclined to make it cash or secured. With that, do you wish to be heard further?
It stands by its written recommendations.
Thank you, Mr. Poston. Ms. Quiroz, I won't do a cash bond, but I will do cash and secured $10,000. You've got a court date of December 15th at 1:30 p.m. That date is unlikely to go. Regardless of whether you postpone or not, no contact with the alleged victim. If you do postpone, you can't go to the incident location. I'm appointing the public defender's office to represent you in this case. On your case with the warrant, my inclination is to hold you on a $1,500 cash or secured bond as requested by the warrant. Does the other party wish to be heard?
No, Judge.
Your Honor, are those going to be running concurrent or consecutive?
They can't, Mr. Becker, because they're in different courts right now, so they have to.
Okay.
Right now.
We would ask for the same points and a reduced bond, Your Honor.
All right, Ms. Quiroz, I'm going to hold you on that $1,500 cash and secured bond. Set your arraignment for December 10th at 1:30 p.m. That court date will go. I'm also going to appoint the public defender to represent you in this case. On your Oro Valley case, I'm going to hold you on a $100 cash bond. I'm going to appoint Richard Glenn to represent you. You're gonna have court tomorrow. It's a video review hearing. It's a case management conference at 10:30 a.m. for Oro Valley City Court. Any questions, ma'am?
There's no way I can be released to pretrial services?
Not today, ma'am.
No. Okay.
You're excused, ma'am. So your name?
Andy Reyes.
All right. Mr. Reyes Martinez, before we begin, your sister is in the courtroom on your behalf, Karen. Someone else here as well? And no, the microphone is stuck. It's not picking us out anymore. Oh, now it's working. Sorry, counsel, my microphone turned off on me. Your mother is also here, sir. All right, Mr. Reyes Martinez, I'm seeing you on two different matters. I'm seeing you on a felony case. Let me pull it up. It's CR 250164555. One count of possession of a narcotic drug, one count of resisting arrest, one count of possession of drug paraphernalia. I'm also seeing you on a city court case for criminal trespass.
Judge, on the felony case, the state is dismissing without prejudice the resisting arrest charge and suggesting release to pretrial and steps on the remaining charges.
Just next to the charge on top, if it's only one charge, just do a hyphen. This, if it's not the whole thing. Or just move to a charge or so.
Okay. The record will reflect the state's dismissing the resisting arrest charge without prejudice. So, Mr. Reyes Martinez, the state's asking that I release you. I am sure your attorney doesn't have an objection to that. I don't know if you have a drug problem. Have you heard of steps court though?
Yeah, not.
You're being charged with possession of a narcotic drug and possession of paraphernalia. Steps court is a program that allows the state to dismiss the charges that may be brought against you as long as you do the drug treatment that the court orders you to do.
Okay.
Something that you're interested in doing.
I'm willing to do that. Yes.
I'm going to set a steps hearing on December 10th at 9 a.m. You have a preliminary hearing on December 20th at 1:30 p.m. That court date is not going to occur. What will occur is the steps screening hearing. If you don't go to that hearing, you will not be eligible for the steps program, and the state will just prosecute this as a class 4 felony. Understood?
Yes, sir.
I'm going to appoint the public defender to represent you.
At the bottom of the lunch paper, can we make a note, state's motion to dismiss that charge as a for the record.
Yep. Granting the state's motion to dismiss without prejudice the resisting arrest charge. I'm going to release you to pretrial services. They'll tell the judge whether or not you're in contact with them when you appear for that December 10th court date. Okay, Mr. Reyes Martinez?
Yes, sir.
All right. That concludes your felony case. On your city court case, sir, I'm going to release you on your promise to appear at court in front of Judge Bond on December 30th at 9:30 a.m. Wherever you were trespassed from, you can't go back there. You got it?
Sir.
Make sense?
Yes.
All right. I'm gonna write down here, no, you can't go to 3128 North First Avenue. I understand that's where you were trespassed from. So you got a court date on December 30th, which is your city court case, your city court date. Your most important court date is that December 10th date to determine whether you're eligible to be screened for the STEP program. Pick this habit you've got, allegedly got, and have these felony cases dismissed. Okay, sir?
Thank you.
All right, sir, you're excused. Yeah. I don't know where.
I'm sorry, Judge, the sound's breaking up. Did I miss something here?
No, sorry, I'm talking to the courtroom, Mr. Poston. 1 second here.
You
You don't need to tell me your brother nationality. If he's not a U.S. citizen, with a crime, he might be deported.
It was such a similar.
Right now, there's no ICE hold, which means ICE is not waiting for him to bring him. So we used to know right away whether or not ICE was going to pick somebody up. We have not seen that in a while. I don't know what's happening. I don't know if they're not. But judges never. Just are. Only the work. He has no bond. So you should be able to go to jail and let them know, hey, don't just bond. Right? So your name?
Giovanni Sanchez?
All right, Mr. Sanchez Zamora. I'm seeing you on CR 250164661. One kind of aggravated assault, physical injury, serious, one kind of aggravated assault, deadly weapon, one kind of discharging a firearm in city limits. Sir, my inclination is to hold you on a $25,000 cash as secured bond, but I want to hear arguments from the state as well as defense counsel. State, you want to go first?
Your Honor, this person is alleged to have shot somebody in the hand with a firearm. We don't know what condition this person is. We don't know if they've lost their hand. We don't know what's going on. But what we do know is it's been alleged that this person has demonstrated the ability to shoot another person. And we don't know if this person is in the ER. We don't know where they are. This person is a danger. This person not only has demonstrated the ability. Suffice to say, Your Honor, if Your Honor's first initial indication is $25,000, the state would highly recommend something higher, perhaps $50,000. This person shot somebody. This person is lucky that there's not somebody in the morgue right now.
Mr. Becker? Thank you, Mr. Poston.
Sure, Your Honor. I'll split my argument into two parts. I'll talk about his kind of environment first. He has priors, but his last prior was from 2014. It looks like he did that successfully. He's had no failures to appear in the last 2 years. he has a residence, he lives with his wife and his child. And so that's that part I was asked to take into consideration. The other part is while I'm reading this interim complaint, with my defense attorney brain, here's what I'm saying. The alleged victim went to Mr. Sanchez Zamora's house to accost him about something with the intent to, at a very minimum, start some kind of argument. Mr. Sanchez Zamora shows up to his house later, and the victim comes up to his car. Certainly not with the intent to have a nice, friendly conversation, but to have at least some kind of argument. And as Mr. Sanchez Zamora says, the victim punched him in the face. This is a stand your ground state. You are allowed to defend yourself. And if you are facing, possibly deadly or serious physical injury, you can respond. And that's what I'm reading here that Sanchez Zamora did. Now, certainly that's not for me to decide. That is something for a jury or a plea or something along those lines to decide. But reading this interim complaint, it is very unclear as to the actual nature of what happened. And I think that should leave in Mr. Sanchez Zamora's favor here, Your Honor. I understand that, sure, if these things are, if he's found guilty in all of these charges, sure, that an $100,000 bond might be warranted. However, he's not. These are allegations. And of course, the alleged victim is going to say, oh, I did nothing wrong in this situation. So I would ask that the court take that very heavily into consideration here and release Mr. Sanchez Zamora outright to pretrial services to get this situation dealt with. In the interim, I'm asking for a nominal bond of $2,500 secure. So that way there is some motivation for him to return to court, but also taking into account the gray and murky, obfuscated nature of this case. Thank you.
Mr. Sanchez Zamora, I understand what your attorney is saying. I also understand what Mr. Poston's saying. I'm not here to weigh what occurred or didn't occur. I'm going to hold you on that $2,500 cash or secured bond that I already suggested. Appoint the public defender to represent you. No contact with the alleged victim. You can't go to the incident location. You've got a court date of December 15th at 1:30 p.m. That court date is unlikely to go. Talk to your attorney about your next steps, sir.
Your Honor, what was the amount of that bond?
$2,500, 25000, cash or secured.
Your Honor, I'm confused. Are you saying 25,000 or 2,500?
I'm so sorry. 25,000. I'm sorry, Mr. Becker.
No worries. Just wanted to make sure. Thank you.
Thank you.
And that was secured, correct?
Yes, yes, sir. Cash or secured. I've done that a lot, much to my own embarrassment.
Perhaps court staff can get you an espresso machine, Your Honor. It helps you a great deal. Helps me a great deal, sir.
Not a bad idea, Neil.
Even better Cuban coffee.
I like the Vietnamese coffee.
Haven't had the pleasure.
Oh. Sir, your name, please.
Timothy James Wigginton.
All right, Mr. Wigginton. Continuing on CR 2501644. This is one count of possession of a dangerous drug, one count of possession of paraphernalia.
Yeah, okay.
Mr. Wigginton, maybe talk to your attorney about when your release date is supposed to be from DOC, and they can decide whether or not they want to let me know that. Becker, you hear that?
Yes, Your Honor. I think I'm sorry. Can you say that one more time?
He's got a DOC hold. He's steps eligible. I want to know when his release date is. I don't know if you want to tell me that or not. When his,
Okay,
when his final day is from GSC.
It's not for January of 2026.
January, what was that again, Dale?
It's a January of 26.
Thank you.
I got it. Thank you.
Oh, I see it. I'm sorry. It was right there. Mr. Wigginton, my inclination is to hold you on a $1 bond. You can post that bond and be shipped back to DOC, or you can stay in county jail, presumably killing your number in DOC in 6 weeks. My other inclination is to set a steps hearing on December 10th at 9 a.m. I don't know if you'll be transported for that or not. I'm looking at your priors, and I'm assuming that you had a drug problem for a while and that getting treatment for that problem would be in your best interest. I don't know if you're going to be steps eligible. I don't even know if you're going to be transported for a screening given the DOC hold. But my suggestion would be that if you're brought to jail on December 10th, you don't refuse transport and you go to jail and you go to the court on December 10th, sir. Does counsel wish to be heard on my suggestion?
Nothing from the state.
Your Honor, I think I'm in agreement here with the $1 bond. That way they'll hold him in the jail and Steps can decide if Steps can take his case. I think that'd probably be better.
Mr. Wigginton, you understand what happens if you do post that bond, right?
Yeah,
You don't go to the street, you go back to DOC.
so is it? So I'm better off just staying here.
I mean, that's up to you, man. I'm gonna give you the option to post the bond, go to DOC, or to stay in the jail and kind of kill two birds with one stone right now. And hopefully you'll be transported to the jail for a steps screening to see if you can be eligible for that, man.
Okay.
I'm gonna appoint the legal defender to represent you. I will set a steps hearing on December 10th. I'm also gonna set a preliminary hearing on December 15th because you're in custody. The December 15th court date is not gonna go. If you do post bond, I'm gonna have you call in pretrial services. All right, I don't know what's going on with your life, man, but at least there'll be somebody there who can tell you when your next court dates are and can kind of monitor, at the very least, whether you're checking in with them, okay?
All right.
All right, man. Unless counsel has anything else, your excuse, sir.
Thank you.
That's it.